I spoke about Section 1(2) of the new Act, which creates a much more rigorous test of what is defamatory where the claimant is a profit-making corporation. And it requires claimants in that position, let's say it's Barclays Bank suing over an allegation of impropriety or something like that, to be able to show more than just some sort of general damage to its reputation, but that some serious financial loss has resulted to it as a result of the defamation before it can claim that it is actionable and defamatory. And that's a great protection for journalists, in particular business journalists. There's more and more law and regulation surrounding the work that journalists do. When I came into the law 30 odd years ago, there was relatively little of it. Now there are reams and reams of it in statute, in common law, under the Human Rights Act. There are all kinds of pitfalls for journalists. And every journalist has to be part lawyer these days, particularly if you're doing public interest work and risking attacking the reputations of the rich and powerful. So it's very important that journalists and lawyers can interact like this, and the journalists can keep up to speed with what the changes in the law are, and the lawyers can get feedback from the journalists about what they see the problems as being. I think it's very early days yet. We're going to have to wait and see how judges interpret some of these provisions, but I think there are just the beginnings of signs that claimants are less willing to use defamation claims against newspapers, recognizing the possibility that they'll face decisions under the new law that are less favorable to claimants and more favorable to newspapers, and will try to look for other ways to resolve their grievances.